So we're at the top of the hour here. We're going to get started. Thank you all for showing up bright and early. You guys are the hardy souls of this conference. We appreciate it. We're going to spend about 45, 50 minutes talking about regulatory issues, Compliance 101. Let me see if I can advance this here. Compliance 101, what regulatory issues and risks do WISPs face? Rather than try to cover every potential regulatory obligation, filing, et cetera, what we're trying to do is touch on at a pretty high level the key issues, the key filings, key obligations that WISPs have, so that you can walk away with a good sense of generally what's required. And of course, if you need additional information, we've got a panel of experts up here. My name is Casey Halm. I'm with Davis Wright Tremaine. We're a law firm with offices around the country. I practice out of the Washington, D.C. office, do a lot of FCC regulatory work, spectrum licensing, acquisition, et cetera. To my right is Steve Bach, CEO of Subsentio. To his right, Chris Toomey, who's the law offices of Chris Toomey. And to Chris's right is S. Janelle Trigg with Lerman Center. And in a moment, I'm going to ask these guys to introduce themselves and give you a little bit of background on what they do and the types of work that they do with WISPs. When I think about WISPs and regulatory issues, I think of it in sort of a good news, bad news paradigm. The good news is that the industry is doing very, very well, as I think everybody knows. WISPs are growing at exponential rates. You are demonstrating that this technology platform is a viable platform. You're showing that your business models work, and you're taking market share from the bigger guys, and you're helping to solve the rural broadband problem, and those are all great things. So lots of good things in the future for WISPs. That's certainly the good news. The bad news is that as this industry grows and takes on more market share, the more the regulators take notice of you. The better they understand your technology, your business, and the more they expect of you from a regulatory perspective. So there may have been times in the past where WISPs were small enough that they could basically fly under the radar and avoid having to do some things without the FCC taking notice. But I think we're at a point where that's about to change. And so it's important for the industry as a whole and you individually to be aware of what your obligations are, to make sure you're complying with the rules, and finally to engage with the FCC. Talk to staff people, meet the commissioners when you can, do whatever you can to be a part of the process. Certainly, Claude and everybody else in the WISPA leadership is helping with that, and you can engage through Claude and WISPA, or you can engage individually on your own. So, what we're going to try to cover today are these key issues. Net neutrality, although a lot of people think that's gone away, that's not entirely true. There's still some issues to think about. There are some disclosures or transparency statements that need to be addressed. States are active here, and there's ongoing litigation. Broadband deployment and mapping, absolutely critical issues from a policy perspective. Privacy and security issues. And then finally, CALEA and DMCA issues. These are those obligations that ISPs have with respect to dealing with law enforcement for wiretaps, and also when copyright holders come knocking on your door saying there's been a copyright violation. And we're going to talk about these issues both from a federal perspective, which Janelle will cover, and a state perspective, which Chris will cover. So with that, I'll ask Janelle to just give us a little brief overview of yourself, and then each one of you can just introduce yourselves.
Good morning, everyone. Can you hear me okay? Excellent. I'm member and chair of Lerman Center's Privacy and Data Security Practice. I've had the pleasure of working with Steve Coran, who many of you know, also a member of our firm who serves as Washington counsel. So I'm delighted to work with you on all different issues related to regulatory, legislative, as well as some practical business issues. I'm also a member of WISPA's CALEA committee. I'm a former broadcast, TV, and sales marketing executive. Please don't hold that against me. But one of the main things is that I knew for more than 16 years the impact of FCC rules and regulations on your business practices. So I look at the regulatory obligations and compliance obligations from a very unique perspective, how it affects your bottom line. I'm also former FCC staff. I happen to clerk for 2 FCC commissioners and served as a senior policy analysis, and I was assistant chief counsel for telecommunications for the Small Business Administration, advocating on small businesses before the FCC, Congress, White House, anyone that would listen. So it's a pleasure to work with each of you, and thank you, Casey.
Thanks, great. Next, we've got Chris Toomey.
Hi, I'm Chris Toomey, law offices of me, and I've been working with you guys since pre-WISPA, where it was part15.org and all the old guys. And I represent WISPs, ISPs, both wired and wireless, and fiber these days, and CLECs and VoIP providers exclusively, and I have for the last 20 years now. Thank you all for coming out early this morning to listen to us. And as they said, I'm going to focus on the states. I was trained in DC, went to law school there, but I spent a lot of my time deep down in the local weeds. So I'm going to give you a little flavor of that once it's my turn.
And next is Steve Bach, who is the CEO of Subsentio. We don't have a slide for Steve, but here he is in person.
I work for the FBI, so I'm undercover. Good morning, everybody. It's great to see this many people here. The last time I talked to WISPAPALOOZA about Kalia, 5 people showed up. And the reason, I suppose, is because none of you have ever had a wiretap request. Am I right? What I wanted to do today is give you some case studies on why you should be compliant with this. I know people have been beating you over the head about it, but I think when you look at the revs and the regulations about this stuff, it just kind of goes in one ear and out the other. So what I wanted to do today is make it real for you. My company has 300 service providers around the world. We've done tens of thousands of wiretaps collectively as a staff, tens of thousands of subpoenas, and tens of thousands of DMCA requests. So I'll be talking to you a little bit more about that later.
Cool. All right, with that, let's jump right into this. Janelle, you're going to start us off on net neutrality issues.
Certainly. Just a little occupational hazard here. I need to read the disclaimer. This presentation is not intended to create an attorney-client relationship, although we would like to have an attorney-client relationship with everyone in this room. The information contained in this presentation is general and not offered as legal advice. You are strongly encouraged to consult with your attorneys if you have specific questions, and any reliance on the information in this presentation is taken at your own risk. Now that I have your full attention, let's talk about some of the issues. By the way, we're going to get more into detail on compliance issues. In fact, forms that you need to fill out. It will be the Chris and Janelle show tomorrow at 4:15 to 5:15. Come join us. We're really going to get into the details of the actual compliance issues. So with that, let's talk about net neutrality. Net neutrality is a little confusing because it really stands for principles that an ISP won't block, throttle, degrade service. The big debate in Washington, D.C. was how to achieve those principles. And as you know, the previous administration adopted Title II, basically classified broadband access information providers as common carriers. So you were subject to Title II. That Title II order was repealed by the new FCC administration led under Chairman Pai. The new Restoring Internet Freedom, we call it the RIF order, was issued just this year, and it was effective in June the 11th of this year. What that RIF order did was to reinstate broadband internet access providers as information services, so you're no longer subject to Title II. Of course, if you have VoIP, Voice over Internet Protocol, you are subject to Title II under the CP&I, Customer Network Proprietary Information regulations. It eliminated the whole regulatory scheme. It got rid of the general conduct statement, which really was problematic because it was so vague and, again, so general, you could be subject to serious fines and penalties or consumer complaints for what is alleged to be discriminatory or unreasonable practices. It imposed enhanced transparency requirements. There was something this new administration did. You basically have to disclose, and we're going to get into the more detail on that, certain ways that you do network management, how you deliver your service, as well as your rates and fees, and again, I'll get into more details. And it also reinstated the FTC, as in the Federal Trade Commission, as the primary enforcement agency, not the FCC. Now, note that the FCC will still police whether you have an open internet transparency statement, but in terms of more enforcement on the content of that statement, that's under the FTC's jurisdiction, under their authority for unfair or deceptive trade practices. Also note that net neutrality has nothing to do with CALEA, which is the Communications Assistance for Law Enforcement Act. You still have CALEA obligations, and of course Steve is going to go to the detail, but there has been some confusion as to this now that net neutrality is gone. It's not gone, it's just being implemented and under a different statutory regime. You still have obligations for CALEA. Reclassification as an information service. Again, you've got consumer disclosure requirements. And what is very, very, very important is that this transparency requirements apply across your entire business. Your service agreements, your privacy policy, your advertising, your marketing, online, offline, public statements are all subject to quote unquote transparency. Basically, the FCC wants you to share to consumers everything that you do so consumers can shop around and compare internet service providers. It's required of all providers, no exemptions. There was a small, remember, ISP exemption under the previous regime when they were certainly more vigorous and more stringent transparency disclosures, but no longer. Every ISP, regardless of size, number of employees, you need to have an open internet transparency statement. The Commission enhanced what was the 2010, and I'll tell you what they did. And they also said that you must post your open internet statement on your website in a very easily accessible manner, or you can file it with the FCC and they will make it available to the public. I encourage you just to post it on your website. I would not send anything to the FCC. Sorry. That means your open internet statement should be available in a link on your website, not buried in another document. Again, it has to be easily accessible. Here's the rule. Any person providing broadband internet access service, the key things are, shall publicly disclose accurate information regarding your network management practices. And again, the Commission basically wants consumers to be able to shop, to compare shop. It controls, as I mentioned, your service agreements, website postings, everything. If your open internet transparency statement is in conflict or inconsistent with what you have in a consumer contract, your open internet transparency statement controls. It governs. And any inconsistency between your online, offline, public-facing documents could subject you to a deceptive trade practice under the Federal Trade Commission, which is why, from a practical perspective, you want your open internet privacy, internet statement to basically be a overarching document. It governs. So you really need to compare what you have in your service agreements. And if you have merged companies, if you have purchased new companies, if you have even been hiring new employees from other companies, you really need to reconcile your different documents and business practices. You must disclose network management practices, reasonable network management practices, performance characteristics, commercial terms. There will be a very detailed net neutrality session tomorrow where I'll actually go through each one of these one by one, but that could take another 20 minutes and I don't want to waste the time here. The key thing for commercial terms, your services and your plans. Yes, you need to disclose the pricing of your plans. I can't tell you how many internet service providers I talk to that don't want to disclose that because they're afraid that the competition will see it. Well, that's the very purpose of the rule, unfortunately. So they're expecting you, the commission is expecting you to disclose everything. And fees, that's every fee, whether it is one time or reoccurring. Everything from your postal fee, if you're going to charge $4.99 to send a paper invoice, that needs to be disclosed in advance. California also I think Chris is going to go more into the states, but beware of California. California is on the cutting edge of just about everything: privacy, data security, and now net neutrality. He'll go into more details with that. Broadband deployment. That seems to be the hot bipartisan, believe it or not, issue in Washington, D.C. Everybody wants to have more broadband deployment. The issues are, how do you get there? Congress is engaged. There's multiple bills pending. There's bills that have been passed. WISPA has been very much engaged in lobbying for or advocating against. The FCC has a host of issues and proceedings, everything from Universal Service Fund and the CAF Fund, your infrastructure reform rulemaking. I mean, this could be a full page. These are just a few of the main things. The Broadband Deployment Advisory Committee, which Elizabeth Bowles serves on as chair, has been very active. And I also happen to have the pleasure of representing WISPA from an appointment from Chairman Pai to serve on the FCC's Advisory Committee on Diversity and Digital Empowerment. I'm in a working group where we're discussing ways to increase access and deployment. And of course, the Rural Utilities Service, which is a division of the Department of Agriculture, they just issued a request for comments on the e-connectivity pilot program, a pilot program that has $600 million. Oh my gosh, pilot program. The problem with RUS, as you know, is that agriculture, from its history of promoting incumbent telecom and rural cooperative services, they have been very, I should say, less likely to adopt new technology. So we have really been working with RUS to teach them about the fixed wireless industry. And we filed comments in this e-connectivity program, pretty much said that you need to be technology neutral. You also need to look at the speed of deployment, the cost of deployment, as well as protect against any other federal and state subsidy program. RUS should not give out funds to any entity that's going to overbuild on anyone who got CAF money, USF money, state money, whatever. You really need to serve the unserved. And fortunately, the statute does say that they have to serve an area that has 90% of households that do not receive sufficient access. The problem with that is, how do you measure the 90% of households? Which is where we get to broadband mapping. Broadband mapping is a mess, no doubt. The National Broadband Plan on its website, I actually put what it lists there. It says it's from June 30th, 2014, and it's not being updated. This is a screenshot from the website. Broadband mapping is a mess. The FCC, NTIA, Congress, RUS, the states are all working on ways to improvement. We have actually filed comments in the FCC's 477 modernization program, asking the FCC to first not just do more accurate data, but also don't add additional burdens on small providers in terms of sub-census blocks. The Commission wants to do sub-census block reporting. They want you to report potential customers by road segments, street addresses. How do you do that for fixed wireless? Your technology does not run along streets and roads. And a street address where the actual postal container could be located on a road somewhere in rural America, but the house is 2 miles or 20 acres within that parcel. So we had to educate the Wireline Competition Division on how fixed wireless works. Fortunately, we have had great reception from the staff. In fact, here we just switched to the broadband mapping. Well, hold on. Keep that page. And they now understand that you run your technology basically a little differently. We've been asked to give some input as to how best to collect sub-census data. That's going to happen anyway, subgranular data. But we're working with the FCC staff to try to get a practical approach as well. Also note that WISPA advocated for a continued semi-annual reporting. We know that 477 is a pain, very much so. But without a 477, without filing a 477, you are at risk for someone overbuilding on you. Worse yet, you are at risk for not only an overbuild, but an overbuild based on and funded by government money. State, federal. You need to really complete your 477s. So we've asked for semi-annual. I was talking to Mark Radabon last night. He said that his coverage changes every 3 months. You have the fastest deployment speed and cost effectiveness of any technology. You're changing your coverage. You're adding more consumers faster than cable, than satellite, than mobile, than fiber. It's critically important that fixed wireless, your deployment, your coverage, your great coverage in unserved areas is recorded for the record. So that way, policymakers, other carriers will not overbuild. So that's why the 477 is important. The Commission's also measuring broadband with their mapping for fixed wireless, their mapping for mobile. Again, it's still a mess. 477s, and we'll wrap this up. 2 times a year, still required, March and September. Bottom line, you have to complete your 477s. I can't tell you how critical it is. Here's the further notice proposed rulemaking to modify. This is the Commission, what they asked for. I already talked about that. They wanted to know whether geocoding should be required for all potential subscribers. We said that is very costly and practically impossible. How do you determine where your potential customers are until you actually are on the premises and can measure whether there's a connection between the antenna, the tower, silo, or whatever? You can't do that, and you certainly can't trespass on someone's land to do that. So we again filed comments and basically gave them an education on how fixed wireless works. We can go to the next one. Again, retaining semi-annual and aggregate 477. The other key thing is you, Commission, you ask us for this data, but you don't release it till 18 months later. Why? I actually talked to a staff person. I learned that some of the larger providers are not providing accurate 477s. Oh my. And they have had to go back to them to ask them to resubmit their data, which is hence the delay.
Janelle, when you say larger providers, larger WISPs or larger ISPs?
Larger ISPs, the big guys.
Cable, telecom, et cetera. Yeah.
Yes, the big guys. Yes, correct. And multiple staff and multiple, employees and yes.
Yeah.
So
Teams of lawyers,
I
right,
suggested to the staff that, you know what, if you find one of them with something, a couple zeros before the comma, then I can assure you that everybody will start to file their 477s in a more accurate manner. But it seems to be the whole database is held hostage because they're trying to get better inputs. They've got to fix that. Let's talk about privacy. The FCC broadband privacy rules, that's what's gone away. That was basically rejected by Congress under a Congressional Review Act. It was never in effect. There were no broadband privacy rules in effect, notwithstanding that the privacy activists say that they've lost all this privacy protection. They never had it to begin with. But note that telecom and VoIP providers, you're still subject to the old CP&I rules. So CP&I still is a requirement for your compliance. And if you're offering video, multiple video program distributors, you are also subject to Title VI, which is privacy provisions. Now, granted, there's no FCC-specific privacy rules, but note that that wonderful open internet transparency statement requires you to disclose your privacy practices, and they add "if any" to that. Understand that WISPA obligated this organization, when those privacy rules were first repealed, that WISP would have privacy policies and would comply with basically general privacy obligations. So you still need a privacy policy, particularly if you're going to use customer data in a way outside of your practice. If you're using it for behavior advertising, if you're using it to market your own services and products, if you're using it for search history, et cetera, you need to have a privacy policy. You want to have a privacy policy to disclose how you're going to share information with law enforcement. So that way you're basically managing your consumer expectations. You need a privacy policy, and it should be posted in a clear and conspicuous manner. Note that Federal Trade Commission and state laws. If you're in California, a privacy policy is required by law. Other states may have some other stringent requirements. Nevada and Minnesota. Who's in Nevada and Minnesota? Anybody? My regrets. My sincere condolences. Nevada and Minnesota have the most stringent ISP privacy laws on the books. Both states prohibit the disclosure of personally identifiable information for any other reason than delivering your service. Nevada actually says you cannot disclose someone's email address unless they give you permission. Nevada carries criminal misdemeanors with fines for violations of the law. Minnesota is worse. Minnesota prohibits disclosures of viewing and search history of your customers. That too carries statutory damages. Look for more states to follow. California, like I said, just had the most stringent privacy law in the country because they adopted provisions similar to what I call the goddamn privacy regulations out of the EU. So, privacy, something that's also important. And the last thing, security. Data security is related to privacy, but security is indeed a separate obligation. Your transparency statements require you to disclose your security practices. Voice, CP&I, and your cable video requires a certain degree of security. How you must secure and not disclose customer information. FTC, unfair and deceptive trade practices. If your security statements are not accurate, you're now subject to a deceptive trade practice. If you have no security, you could be subject to an unfair practice because it's unreasonable for you to not have such security practices. All 50 states, DC, Virgin Islands, territories, have what's called security breach notification requirements. So if there is an unauthorized disclosure, whether it's an internal hack or external, you have to now disclose to consumers certain obligations and certain information. States also have standards for collecting, disposing, sharing data. Your government is also working on your cybersecurity standards and rules. And insurance carriers and payment card data security standards, if you are processing credit card payments online, if you have engaged a third party to process payment card obligations online, they are subject to more stringent regulations than the government can because those regulations are coming from Visa, MasterCard, American Express. So you are still responsible whether you hire a third party, vendor, or the next door neighbor to process anything online. You must have data security standards. And they say that the internet is not regulated. Thank you.
Great. So next up, Chris Toomey. And while we're doing the switch here, let me just announce that we'll hold questions till the end. We'll have about 10 minutes for questions. And with that, I'll hand it off to Chris. Clicker on the right there.
Thank you. So as I said before, I'm deep in the weeds with the states and representing ISPs across the country, both wired, wireless, fiber. And I'm the guy that argues with the permit office in Escondido or complains to the city attorney in Tallahassee about their anti-competitive relationship with the utility company and access to poles and stuff like that. So I am down there with you trying to figure out each state, each locality, even in terms of how to actually deploy services. And as you may have noticed, the country's a bit divided these days. There's always been the inherent tension of federalism with telecommunication services. The difference now is that it's actually relevant to people, to consumers, to voters, and most importantly, to regulators and people who want to get elected. Telecom is actually suddenly a topic that you can make some hay with. And the way it used to be, when I first started working, I worked in DC, and we were doing stuff that it was arbitrating interconnection agreements against the ILX, fighting about access to unbundled network elements in the unbundled network element platform, and whether access charges applied to IP-enabled calls. The kind of stuff that you just didn't hear about in the news. Now, you have things like security, privacy. You have people losing their minds about net neutrality. And while all that's going on, you have this tribalism where there's a gaping gap between one side and the other. And strong opinions on all sides. And in the meantime, you have a dysfunctional, non-bipartisan Congress that can't pass statutes to kind of pull all that together so that the states can follow federal rules. So what you end up with is if there's this hole, the states will fill it. And that's what's starting to happen. And you'll see that the typical suspects of state action in this kind of climate would be something like California, New York, and Washington. But there'll be some wrinkles too, where you'll have some states like in Oklahoma that you wouldn't expect to do a whole lot to fight this federal government anyway. It's been flipped a little bit. I'll get into that in a sec too. So you're right, though. I'm a political science dork, and one of the funny things about this for me is that you have the FCC trying to impose, Republican-controlled FCC trying to impose rules that the states and localities have to follow. And then you have the left states arguing for states' rights. It's all backwards, but in everything a little bit backwards now. So if you come out here with one thing from me, it would be while WISPA is great at advocating for WISPA on the federal level, they don't have the resources to tell you what's going on in the state level. And you need to know what your state is doing. So you need to gather with your fellow WISPs in each state, understand what's going on, advocate your positions at the state level, and even at the local and county level, so that you can first, that you know what's going on, and then second, so that you can make your voices heard, because you're the good guys, and they want to hear from you. So that's my one takeaway. Make sure you walk away with that. So the only class I liked my first year of law school was constitutional law. Everything else your first year of law school just sucks. It's so boring. Con law was fun though. And what this current telecom federalism thing that's going on points out is the 10th Amendment. It's kind of vague. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or is reserved to the states respectively, or to the people. What does that mean? Whatever the hell you want, if you're a state looking to step into a vacuum. So the arguments right now around the issues like net neutrality and privacy and security and the policies that are coming out of the Broadband Deployment Advisory Committee, the BDAC at the FCC, as all this stuff filters down and actually has to be implemented, you have this fight about is the FCC actually regulating and pushing things down? Or, like with privacy, are they stepping back and leaving a hole that the states can fill by releasing internet services from Title II, making an information service? They did say in that order, states, you stay out of this. This is our jurisdiction, but we're not going to regulate this. We're moving it to information services. What does that mean, though? Does that mean that the states are precluded from putting in their own rules in, like California? Like, there are two different kinds of net neutrality rules. There are the kinds where they're kind of wishy-washy, where it says, well, state agencies can't do services with providers that don't follow net neutrality principles, like in New York. And then my wife moved us to California for her job about 4 years ago, and I live 2 towns north of Golden Gate Bridge. I'm living amidst the vanguard of the resistance. And there, like Janelle said, you have net neutrality rules where they're very strong. They're even stronger than the FCC originally had. And the same thing with security and with privacy. These rules where the states are looking to fill in the gaps where they think they can protect their citizens from what they see as an overreach by the federal government, or backing away and not protecting the citizens. So I don't want to get into every single permutation of the different state attempts on net neutrality or security or privacy or anything else. So what I would say is you need to educate yourself about what you're doing and whether your policies actually match what your state requires. Because your practices do. You guys don't play around with subscriber data usually, most of you. You're interested in privacy. You're not one of the big providers who's looking to sell third-party information. So you're already doing the good guy stuff. But again, like Janelle said, you have to have these policies in place. You have to have your net neutrality statement or your internet transparency statement these days on your website. Have an AUP on your website, privacy statement, security statement, all that stuff. Just have a legal link where it lists all the stuff that you actually are following for your customers. And if you look at like a state like California's rules, if you follow those, which you already do in practice, put those into writing and put them on your website, it's actually something that's a marketing tool. You guys are doing the right thing, and you're bringing services to places where it doesn't normally go. And you're also protecting people the way that both sides of the aisle in both the states and proper thinking people in the federal government think you should be doing. So get it out there, and you can protect yourself from potential weird calls from state agencies that you've never heard of before that'll start popping up. The other reason to put this stuff up there is when you have this level of polarization and the politicization and the publicization of all these kinds of issues, it increases customer awareness, which is both good and bad. You can be good in that you can use it to your advantage. I never really understood WISPA's problem with net neutrality, honestly, because you already do it primarily. But at the same time, I thought it was good for it to be repealed because it gives you guys an opening to say, hey, look, we are net neutral. We are out looking out here for you. So you have, as it goes on, you need to highlight this and follow what the states are telling you how to stay within the lines, like a state like Nevada. Tell customers, look, we are not Cox. We are following your rules. I want to talk a little bit about some of the things I've seen on the state level. I don't want to make sure I give enough time so you can hear about DMCA and CALEA and get some questions in too. But, 2 more minutes, yeah. One of the things that blows my mind is that there are 25 states that currently regulate VoIP in one way or another. And that includes either having to actually register, like a state like Missouri, where it's just as bad as a CLEC application, or a state like Illinois, you have to fill in a form, a state like California, where there are 7 different silly state USF funds that you have to send reports in every month on and pay into. Of course, there are some states like North Dakota and Florida that essentially don't care. But it blows my mind that the VoIP providers who are WISPs don't always know what's going on. So I would suggest you to go look at your state utility commission website and make sure that there aren't any obvious forms that you need to be filling out on there. We'll get into that tomorrow at our poorly named forms panel. But make sure you know what is required on a basic level, because it's just easy to stay out of trouble that way. And for example, so VoIP is a particular example that there are regulators want to regulate, right? In most cases, anyway. And there's a lawsuit in Minnesota where the Minnesota PUC went after Charter, trying to force them to treat VoIP as a telecommunications service. Minnesota lost. On the other hand, in Vermont tried to do the same thing. Court said, yeah, go ahead, make your own rules. They haven't done it yet. But the rules are all over the map and they are changing. But as VoIP becomes a bigger service, it's overtaking POTS at a rapid level. It's like 15% of consumers still have POTS. So the states are going to treat it like a regular telephone service. And as broadband continues to become critical, all these rules are coming down on you. So keep in mind that it is a wave that will continue to go on. And with that, I will just drop it and let you guys get on to DMC and CALEA.
Great. So next, we've got Steve Bach, CEO of Subsentio, which is a vendor that handles CALEA, DMCA, and other technical issues.
Good morning. So I'm not going to bore you with laws today. What I'm going to do is give you case studies, because I guarantee you that someone in your network is doing one of the following things. They're a pedophile, and they're looking at child pornography. There may be someone threatening to commit suicide, a child. And I absolutely guarantee you that most of you have people that are illegally downloading videos, music, and so on, copyright infringement that could sink your business. So what I want to do today is go through some case studies. Our mission is to catch the bad guy. If you go to our website, you'll see that about a third of the people that work at Subsentio are former law enforcement officers with the FBI, DEA, ATF, and so on. I started this company because of the events of 9/11. I was actually driving into New York City on that day, and I took the first flight out of LaGuardia on that Saturday. It was me, a really pissed off pilot, and 2 stewardesses who couldn't stop crying. I just happened to have started a job working for a CALEA manufacturer. And that manufacturer was great because we could get multi-million-dollar POs from AT&T and Verizon. But when it came to you guys, it didn't make sense because we were giving you quotes for $1 million when you only had a few subscribers. Thank you. Money never sleeps. So what I want to do is just talk about some misconceptions. First of all, electronic surveillance for WISPs is not required. It is. Enforcement never occurs. It does. DMCA is not a WISP issue. It absolutely is. 911 is good. Wiretaps are bad. Big brother stuff. And finally, that size matters. The smallest company that we've had that has had a lawful intercept requirement, a wiretap, was 350 subscribers in the Shenandoah Valley. So I want to start with just some infamous wiretaps, just to get your brain around this a little bit. This guy actually was the investigator for the STARS. And he convinced a telephone company person to illegally wiretap the stars that were hired by him in order to help them in cases like divorce. I think Tom Cruise was one of his clients. He's now in jail. Then, of course, there's former President Nixon, who wiretapped himself. You may find that a little odd, which it was, but we've actually had cases where we have consented to do a wiretap on someone because their child has been kidnapped. If you're not prepared to do that, you should be. And then finally, I'm from Colorado, so I have to talk about Blagojevich, who's sitting in jail in Colorado for an illegal wiretap that caught him trying to sell Obama's Senate seat. We've rejected more than 10% of the court orders that we receive. It's really important that you have a lawyer look at these things that understand the law, because if it's not correct, you're going to be held liable for it, especially on the right to privacy issues. So I've listed some of the things here that are problems when we're reviewing court orders. We do more FISA orders than we do criminal. FISA is the Foreign Intelligence Surveillance Act. It's been in the news a lot lately. But I want to tell you that ISIS is under investigation in all 50 states. We get a lot of terrorist court orders to prevent terrorist activities. So I just listed a couple things on right to privacy issues. A lot of these things have to do with location. And as the folks talked about earlier, the laws, there's not just the federal stuff, that the state as well. You really need to understand what the laws are in your particular state when it comes to protecting yourself. So how do you protect yourself? Well, there's a statute within CALEA that's called Safe Harbor. And basically what it says is as long as you're providing industry acceptable standards, you're in safe harbor, okay? What that means is if you think that your technician can just store information on a wiretap and forward that to law enforcement down the road, that is not a standard. And I hear that all the time. Why is that important? Real time, getting information, intelligence, real time while someone's listening or watching is critical. And I asked the cop once, so why do you need it so fast? He said, well, if I have someone that's undercover and they say, this guy's a cop, let's kill him, I can't find out that information a day later. So one slide on enforcement. Show cause. This is the most common thing that happens. It happens all the time, where you're not compliant and you get hauled into court and you end up having to hire a really expensive Washington, D.C. lawyer, and they will defend you in court. And why do all that when all you had to do was be compliant? The DOJ also has the ability to impose these kinds of things. Both of these cases, you can be fined up to $10,000 a day while you're not compliant. The FCC can bring enforcement. We have a client that went with another competitor. Stuff didn't work. The FBI had a mission to do, so they put their own equipment in for free. Great. But then they filled all those 4 ports up very quickly, and the DEA called. They had a court order too. And when they couldn't use the FBI's facilities, they complained to the FBI. FBI went to the FCC, and now they're sitting in front of the FCC with a potential large fine and enforcement decision that we were able to help them with. Subscribers. This is probably the most important thing. If you're not compliant, the FBI may come in as a last example and put stuff in for free. But you don't want to do that because the FBI will suck everything out of your network. And guess what happens if someone finds out and the subscriber thinks that they've been violated on the right to privacy issue because they weren't part of that investigation? You're the ones that are going to get sued. The Department of Justice is not going to give you a waiver on that. Landmines. Subpoenas, we do that as well. There's literally 1 million subpoenas that are issued every year. These are historical call records going into your database to find out information going back and forth on IP addresses or phone records. One company I know of in Nebraska decided to send their subpoena to a lawyer in Lincoln, Nebraska to have it checked out, and he said, you don't need to worry about it. There's a child pornography case. The sheriff department literally surrounded the building, would not let anybody in or out until they complied. Now, is that a little bit heavy-handed? Yes, but trust me, the cops want to catch the bad guy like we do. When it comes to pedophilia, nothing gets the cops more riled up than that. This case study is about a company that had taken an IP address. You know, the cops come and say, hey, is this your subscriber? Is this your IP address? Yeah, well, look up who it is because we have a subpoena. And they did, but they got one digit wrong. And that meant that they were knocking down the door of the little old lady instead of the target. They got sued, and they settled out of court for $50,000.
But paid lots of legal fees.
Exactly. Lawyers always make the money in these deals. And then finally, DMCA, which, you know, there was a case with Cox Communications where they had to pay a $25 million fine for not being compliant with DMCA. You got to respond to those things, guys. We recommend a 6-strike rule. You can do it less, you can do it more, but figure out a policy with your lawyers so that you're protecting yourselves on people that are downloading things. A lot of times, this is the teenager or the granddaughter that doesn't even know that it's illegal to download Game of Thrones or whatever. So to conclude, wiretaps are just as crucial to public safety in my mind. Help us catch the bad guys. They are in your networks. CALEA it really does protect the privacy of the individuals. It's mandatory for you guys. Quarters are increasing, not decreasing, and the cost of compliance is a lot less than going to court. I have this story, but I don't know that we have, do I have 1 minute?
Yeah.
1 minute. Yep. Wiretap story. Just has nothing to do with all the stuff I just talked about, but I think it's funny. Okay. This is the days when the FBI did not need your help. And so this guy, Mike, I won't tell you his last name. He actually was a FBI agent and ended up being a consultant for CSI here in the Nevada show. He tells this story where a cop got killed on Long Island. And everybody's looking for him, including the mafia, because they knew it was a mafia hit. And so Mike is in the telephone van on the side of the road, and his partner's up on the pole getting the wiretap set up. And a guy, we'll just call him Guido, saunters up to the van and says, hey, you got a smoke? And he says, no, I don't smoke. He says, you're not with the effing phone company. Everybody in the phone company smokes. You're a cop. And at that point, Mike started to reach for his gun, and he said, don't worry about it. By the way, you're on the wrong pole. He's on that one over there.
2 quick notes, practical notes on CALEA. WISPA has adopted standards that if you are a member of good standing for WISPA, it's available on the members only site. And it was in conjunction and cooperation with the FBI. So we worked very closely with them to get practical standards. Also, many of you have subscribers all on one IP address, right? And government wants to know a particular target. You cannot hand over your entire IP address. Basically, you'll need to explain to them and walk them through your process and have them further identify the target. But just because they ask for an IP address, again, if you've got multiple subscribers, 99 subscribers, only one of them is a target. You then violated the privacy rights of 98 of them. So you need to really work closely with law enforcement, consult with your counsel in advance, have a policy for law enforcement requests in advance, so when the fax or the subpoena or the FBI comes knocking, and sometimes you won't get any paperwork, they will show up at your door, you need to have a process in place before that happens. Or you get a national security letter, which is, again, you've got a gag order, there's all kind of obligations for that. That's right. But you can consult with your attorney. The gag order does not apply to your legal counsel, okay? And again, we can review, or if you are under contract or you're one of Subcentio's clients, talk to somebody first before you just hand over. No matter how bad that case may be, again, they could be looking for a child pedophile, you have got privacy rights and obligations under other state and federal laws. You have to cooperate, but you need to do so in the proper manner.
Great, thank you. So we have a little bit of time for questions. If anybody does have a question, we ask that you come up to the mic. This session is being recorded, so we want to make sure the questions are recorded. I'll take the prerogative of being the moderator and ask the first question while we wait for some folks. This goes to you, Janelle. You talked early in your presentation about the fact that the FTC, the Federal Trade Commission, now has authority over internet transparency and internet conduct. Can you talk a little bit about exactly how you see the FTC regulating in this space?
Certainly. The FTC has always had authority, except it was challenged by AT&T in the AT&T mobility case. The FTC, the Federal Trade FTC Act, provides authority for the FTC to enforce against deceptive or unfair practices. And unfair practices is very general. And deceptive practices, of course, is what it says. If you say one thing but do another, whether it's in your privacy policy, your open internet transparency statement, your advertising, anything, the FTC then has enforcement. Now, most likely it comes from a consumer complaint. You know, the FTC isn't necessarily trolling the internet or the website, but it has to come through a consumer complaint, and then they will launch an investigation. You do not want to be subject to an FTC investigation. It is extensive. You will get a letter that could be single-spaced for 3 pages, asking all kinds of details. Your first line of defense then is to talk to your lawyer to try to get what the FCC is getting to. Understand that Federal Trade Commission enforcement is different than FCC enforcement. The FTC can impose fines, millions of dollars in fines. Your size does not necessarily matter. Worst off, they will also impose what's called reporting conditions. So you will be subject to 20 years. I repeat, 20 years of reporting conditions, which means you have to file a document with the FTC for 20 years on how you're complying with their mandate or their decree.
Ouch.
So the Federal Trade Commission is the new, and that's not so new because they've had enforcement actions against ISPs before, large and small. And the FCC, one important thing, the FCC and FTC work together on this. They have a memorandum of understanding. They have meetings between not just their Consumer Bureau and Protection Affairs, but also certain bureau chiefs. The 2 chairmen are good friends. They will refer each other to particular investigations. So you could initially start out with an investigation by the FCC, which gets referred to the FTC. And understand that if the FTC will publicize it, then you're subject to state law enforcement.
Thank you. We'll leave the state law for a later time because we have a lot of questions. Please.
Okay, we have a WISP near us, and on their webpage, they advertise pricing starting at X dollars, speeds up to a gigabit, and nothing in between. That's all they have on their webpage, and when you call them to get pricing, they require, they require your full name, address, and phone number before they will give you any information at all about their pricing schemes. So and you alluded that the WISP should have this speed for this price, this speed for this price, data caps, throttling, whatever. That should all be
Disclosed.
disclosed.
Right.
And they will not disclose anything until they know who they're talking to.
Right. So the question is that a violation of these transparency?
How's that addressed?
Janelle, you want to take that?
Yes, that would be a violation of the Open Internet Transparency Statement because they need to disclose all the service plans and speed and actual and average latency and speed as well. They have not disclosed that, so the question is, who would enforce that? If they have an Open Internet Transparency Statement and it's just vague, the FCC may very well enforce that first and then refer to the FTC as a deceptive practice or unfair trade practice. But that is not an Open Internet Transparency Statement.
So who does that get reported to? What office does it?
You could report it to the Enforcement Bureau at the FCC.
We've had potential customers come to us and say, why can't I get a gig from you for $35?
Right.
Because that's what they're advertising on their webpage.
They seem to be advertising in manners that are unfair or deceptive.
I have a client in a very similar situation, and I told them, I said, well, there is an email address for informal complaints about this. So somebody in a cubicle will get it, and they will ask at the FCC. But I'd also say this, is that The FCC has just started this past month sending out nasty manila envelopes for companies that don't have internet transparency statements online. So they are looking. So if you just want to let someone know, nothing will hurt by having a little email sent to that email address.
And maybe after the session, these guys would feel free to help you connect with people at the FCC that might take a look at that.
Just to follow on that, what if you offer different speeds, in different markets? I mean, there's some WISPs here that are in multi-states, and if you're kind of on a more rural part of their network and behind trees, you're not going to offer the same speed as the guy that's next to one of your
That's perfectly fine. You basically, you can organize your open internet statement by state, or you can organize it by service plan. Again, there's going to be a difference sometimes between residential and business. Note that your dedicated internet access lines are not subject to your open internet statement. Your open internet statement is only for your mass market retail service. So if you're doing customized internet for business enterprises, for governments, for other non-residential institutions, that's not subject to disclosure of your speeds and prices. It's just your mass market. But you can, and I also recommend that if you have a link in your open internet privacy, why reinvent the wheel all over again? Basically incorporate links to what's on your website in your open internet policy, so that way if you change your website, you're automatically following the most current data. But you can disclose by state, you can disclose by plan, how you want to organize your service plans by state, speed, or whatever are perfectly fine.
Okay. My actual question is related to the wiretapping CALEA. For example, like McDonald's has Wi-Fi hotspots everywhere. We're not going to see beyond the edge of the connection that we sell to McDonald's, or their third-party provider. So if we get a wiretap request for child porn, behind one of those IPs, do we have any exposure by handing over that IP to the to the authorities when there may be hundreds or potentially thousands of unidentifiable customers behind that?
I'd say yes, because that subpoena, that national security letter, that law enforcement request is not specific enough to identify a particular target. Yeah, they should be going to the McDonald's, correct. Again, the law enforcement request needs to have certain specifications. Otherwise, you have then violated the privacy of the other customers or other consumers. And that subjects you to a whole host of other issues which you really don't want to deal with.
Those consumers are not your customers. McDonald's is your customer. You can say it came from this IP address, then they go to that customer.
Okay, the comment has been those consumers are not your customers, they're McDonald's customers. You're basically just providing the IP address and the link, and that's correct. So basically you need to tell law enforcement, talking to them, the FBI's not bad guys. There's some good people there. Tell them what the situation is, and you say you simply cannot provide that information.
Thank you. Next question.
Good morning. So the broadband mapping is a complete mess, but we are coming up on a census round in 2020. Is there any effort at the federal level to use that data collection to improve the system, or at least get a baseline of some sort?
Well, the problem with the census data, that's a mess too. So one mess plus another mess, unfortunately, you get in regular math, two negatives make a positive. You get no positive out of this. There is effort to collect other data, particularly from challenges through some of the subsidiary programs. So if indeed, for example, you are, a competitor is coming in, you can provide more specific information, and they're trying to update the maps there. NTIA, which is a division of part of the Department of Commerce, is also working to try to update the national broadband map. So there are multiple fronts on trying to update it, but everyone in the federal government recognizes it's just a mess. So unfortunately, I don't believe there's really a concerted effort to incorporate some census data, because some of those initial questions and processes, I think, are flawed as well.
If those challenges are coming against a state award, is there any way to seamlessly provide that data to a federal level?
Yes, absolutely. In fact, some of the states are working with the federal database, and there's multiple databases. Again, it's not just the National Broadband Map, and they are, some of your state subsidiaries are, subsidies, I should say, are working under the federal plan because the states don't have it. And we also want to make sure that the states talk to the feds. That's the biggest problem. There's no communication cooperation between the two. And we can talk offline about some ways
Is there
to get that.
anything we as WISP can do to help our state work better with the federal level?
Let's talk offline. We're working with that as well. Thank you.
My question may be a bit of a difficult or impossible question to answer, but I'm a brand new WISP. In getting started, I sought out a local attorney who strongly cautioned me or encouraged me to work with somebody who's better suited to answer questions around regulation. Am I better off trying to look for someone like Janelle or Casey at the federal level, or work with somebody like Chris? And I'm just using general terms here. What would you recommend as the next step here? Is it best to just kind of leap up if I'm only working in one state just to the federal level, or what would you recommend there?
I would say this, that I tell local lawyers, a lot of my clients have local lawyers, and I tell them, you stay out of my lane, I'll stay out of yours. I don't know anything about anything other than telecom, and they don't know telecom. So I would say, first of all, in some states, there are, if you're really concerned about highly state-specific kind of stuff, or if you're in a state like Missouri, New Jersey, Michigan, all the states that are really protective of their state bars, there are state-focused telecom lawyers. But any of us are able to read the state stuff that's going on as well, and we can educate ourselves. So it's really a question of how deep into it you are, which state you're in, because if you're in a state that just doesn't give a damn, then you're okay. You can use whoever you like.
I would agree. Let me add one point here, and that's about time management, because we're past the hour. I want to be respectful for folks that are coming in for the next session. I agree with Chris. I think it's more a matter of, are you finding an experienced telecom lawyer? Most of us, work at the federal and state level. Chris does a lot of federal stuff. Janelle and I do state work as well. So it's really a matter of finding an experienced telecom lawyer as opposed to a non-telecom lawyer.
And there's a need to reconcile the state laws with the federal laws. So you need someone that knows both, because sometimes there's a conflict.
Sometimes they both claim to have precedence.
Right. We got one more question back there, but feel free to come chat with any of these folks.
So if I was to have someone from DCI or FBI contact me and say, I need information about this IP address, and I say, that's a natted IP address, I've got 38 people behind that, I can't get to that information. They say, well, we're going to hand you a subpoena for all the information from anybody who might possibly use that IP address. Do I have to legally give that to them?
Stevie, you want to take that?
My answer is maybe, but he will give you.
Well, that's about the same thing I'm going to say is maybe. This is a huge issue. I mean, we do wiretaps on planes. Are we going to wiretap the whole plane? So the natting issue is something where we try to get to the edge as best we can, but not over collect.
So I would first make sure that tells, even because it may not be.
There's no specificity in this one for the entire 30.
Right.
All right.
Thank you.
Great. Thank you all for coming.
And stay